Welcome back. So today we're unpacking a truly bizarre constitutional court case out of South Africa. It's an explainer that really bridges that massive gap between the lofty, idealized theories of constitutional law and the gritty, completely unglamorous reality of underfunded courtrooms. The case is Jaipal v. the state, and it's just a fascinating dive into how everyday, mundane office logistics can actually trigger a full-blown constitutional crisis. Picture this. You've got a high-stakes murder trial. A man's life and freedom are hanging in the balance, right? The evidence is super complex, there are tons of witnesses, and the tension is just palpable. Now, I want you to imagine that this entire trial and an eventual 20-year murder conviction is brought to the absolute brink of collapse. And we aren't talking about suppressed forensic evidence or some lying witness here. No, it's brought to the brink by an awkward seating arrangement. Seriously, can sharing an office actually overturn a murder conviction? Well, to answer that, we really have to look at the legal mechanism that brought this incredibly mundane issue all the way up to South Africa's highest court. It's called a Section 317 special entry. Basically, this is a procedure under the South African Criminal Procedure Act that you use when an accused person believes something irregular, something not strictly by the book, happened during their trial, even if it's not actually captured in the official transcript of the evidence. And in this case, the irregularity was enforced proximity in a tiny little office. But before we get to the office drama, we kind of need to understand the stakes. Part 1, the crime and the trial. Okay, let's dive into this. In October 1997, a 39-year-old widow named Argentina Lutsaris was brutally murdered in Durban. A man named Shane Jaipal was charged with her murder, and his trial kicked off on June 12, 2000. Now, Jaipal's entire defense rested on an alibi, and he backed it up with official telephone records from Telkom. But, and this is a big but, just 4 days later, the state brings in a Telkom employee who absolutely destroys this alibi, proving those documents had been falsified. So the state's case is looking rock solid. But then, fast forward to the 8th day of the trial, and we get this dramatic pivot. The defense formally requests a special entry, and it wasn't about the evidence at all. It was about the room that the court officials were hanging out in during tea breaks. To really get why this room was such a huge deal, we need to talk about exactly who was inside it, specifically the assessors. So unlike the American system, which leans heavily on juries, a judge in a South African high court can actually appoint experienced assessors to help decide the facts of the case. Crucially, these folks are sworn members of the court. And get this, on matters of fact, 2 assessors can literally outvote the judge. This means their absolute impartiality and independence are just as critical as the judges. Section 2, a bizarre office arrangement. So the trial was taking place at the Pinetown Magistrates Court, which was a facility suffering from a severe lack of space. During court recesses, you had several people awkwardly crammed into what was essentially the judge's registrar's room. You had the 2 court assessors, the supposedly impartial decision-makers, but also in this tiny room, on a daily basis, was the state advocate, that is the prosecutor, and the investigating police officer. And on a few isolated occasions, even the victim's son, who was a key state witness, was hanging out in there. Now, the practical reality was just that the prosecutor had no office of his own and desperately needed the room's only telephone to coordinate his witnesses. But imagine how highly suspicious this looked to the general public sitting in the gallery. The defense lawyer brought this up to the judge with a very measured approach. He actually said, "I know how things work now and then on circuit, but members of the public don't understand how the law works." You see, he totally understood the gritty reality of these underfunded circuit courts, and he actually wasn't accusing the assessors of talking about the case with the prosecutor. But he hit the nail on the head regarding the accused family. They were freaking out, because to them, it literally looked like the court and the prosecution were on the same team, just chatting it up over tea. Let's move to Section 3, the right to a fair trial. The number 15 is absolutely key here. Under Section 35, subsection 3 of the South African Constitution, there are 15 explicitly listed rights for an accused person to ensure they get a fair trial. Things like the right to actually be present, the right to have a lawyer, the right to challenge evidence. But the Constitutional Court has made it clear that a fair trial isn't just checking off a list of 15 items. The concept of fairness is this broad, overarching, integrated right. And this brilliantly illustrates that a trial requires substantive fairness. It goes back to that old legal maxim. Justice must not only be done, it must be seen to be done. Courts have to be independent and impartial, entirely free from interference or even the mere appearance of secret administration. If the public, and especially the person on trial, feels like the whole thing is rigged behind closed doors, The entire legitimacy of the criminal justice system just crumbles. A trial simply has to instill public confidence. Section 4. Actual versus perceived bias. This brings us to a massive legal tension right here. Admitted facts versus public perception. The defense openly admitted that no actual case details were ever discussed in that cramped little office. There was zero actual bias proven. None. But man, the optics were just terrible. To an outside observer, it looked for all the world like the prosecutor and the decision makers were literally sharing a base camp and totally isolating the defense. So how does a court resolve this crazy tension between the facts and the optics? Well, they use what is known as the reasonable observer test. The court essentially asks, what would a well-informed, thoughtful, and objective observer conclude? Step into those shoes for a second. Imagine you aren't hypersensitive, you aren't super cynical, you're just objective and you know all the actual facts, including the fact that the prosecutor only went in there to use the telephone and absolutely no case details were discussed. Knowing all of that, would you honestly conclude the trial was rigged? Now, what's really interesting about this side is how the Constitutional Court distinguished this specific situation from past historical cases that involve juries. See, in older cases, if a court official even accidentally wandered into a jury room, the whole trial was instantly thrown out. Why? Because juries deliberate in total secrecy without providing any reasons for their verdicts. Assessors, however, are totally different. They are experienced legal professionals, and more importantly, the judge has to provide public, reasoned decisions that explicitly explain the court's factual findings. Because their logic is out there in the open and can be scrutinized on appeal, the risk of some secret bias subtly infecting the trial is much, much lower. Finally, Section 5, the final constitutional verdict. Ultimately, the Constitutional Court ruled that this office setup was definitely irregular, unfortunate, and highly, highly undesirable. It was a clear deviation from the norm, and it absolutely should not have happened. However, it was not a failure of justice. The conviction stood. Why? Well, the defense didn't even ask for the assessors to recuse themselves when it was happening. There was zero actual bias proven, and under that objective observer test we just talked about, a thoughtful person wouldn't actually fear bias if they knew all the facts. So the trial, despite the complete logistical mess, was fundamentally fair. But make no mistake, the court was not happy about it. So the crucial point is captured perfectly in this incredibly powerful rebuke from the judgment. To compromise the right to a fair trial may in principle be as dangerous as to cancel or postpone democratic elections because of a lack of facilities or resources. Wow. The court was laying down the law, warning the state that it cannot simply use a lack of resources as a permanent excuse for putting constitutional rights at risk. You can't just throw up your hands and say, well, we accept that the justice system doesn't have enough rooms. The Constitutional Court took this systemic issue so seriously that they didn't just publish the judgment and walk away. Nope, they ordered it to be explicitly sent to the highest authorities in the country, the Director General of Justice, the Judges President, the Magistrates Commission, and the National Director of Public Prosecutions. They essentially CC'd the bosses of the entire state apparatus, putting them on notice to fund the courts properly, ensure clear physical boundaries between the prosecution and the judiciary, and prevent this kind of resource-driven constitutional crisis from ever happening again. And that really leaves us with a stark question to ponder. Can an underfunded justice system ever truly guarantee a fair trial? In Jaipal's case, the conviction held up because the personnel managed to maintain their professional integrity despite being crammed together. But it totally reveals the absolute fragility of our constitutional rights when they crash into logistical realities. Having rights on paper is wonderful, but if you don't even have enough rooms in a courthouse to keep the prosecutors and the judges apart, well, how safe are those rights, really? Think about that. I'll see you in the next explainer.